Hello everyone and welcome to today's session, Data Privacy under the India DPDP Act 2023, What You Need to Know. I am Renal Vicaria and I'll be your host for the day. Before we get started, I would like to go over a few house rules. For our attendees, this session will be in listen-only mode and will last for an hour, out of which the last 15 minutes will be dedicated to Q&A. A brief about EC Council Learning. EC Council Learning is the continuous learning platform by EC Council that offers the world's largest online cybersecurity course library. With 600 plus self-paced courses on this platform, you can build and demand skills in various cybersecurity domains. One of the latest and popular courses on EC Council Learning is Deploy Data Governance and Compliance by Appurva Bhatia. With this course, you will explore the deployment and management of data governance program and get acquainted with the data governance framework to align your company's compliance, privacy, and security initiatives. You will also deep dive into various data governance model and understand the crucial roles of the Chief Data Officer and Data Governance Office. Now about our today's speaker, Appurva Bhatia. He is a Data Protection Officer DPO, Chief Information Security Officer CISO, Risk and Compliance Advisor at EY Advisory, and ex-Global Head of DP at Wipro with over 18 years of leadership and client management experience in IT, BFSI, and healthcare. He is a member and speaker at the US India Business Council, NASSCOM, and other global forums, UAE and India. He is well known for his work in the areas of privacy and security as a policy and functional expert, working to balance privacy and cyber risk with business needs, technology, and growth opportunities, with a focus on the intersection between technology and privacy standards. Working in client-facing role, he has been responsible for the development and implementation of data privacy and security programs to ensure compliance and manage risk arising from global data protection and security regulation across Europe, GDPR, UK, Swiss, US, CCPA, HIPAA, Asia, SG, PDPA, Dubai, DIFC, China, PIPL, India, and more. Beyond work, Appurva is also the founder and director of a not-for-profit organization, www.mastervihanfoundation.com. The foundation works in the healthcare domain to fight cancer and other life-threatening diseases, assisting young families going through medical emergencies and requiring support. For his foundation, he works with colleagues, friends, and volunteers who are also passionately involved in fundamentally contributing to and changing the circumstances of families that require support. To know more about this course from EC Council Learning, I would now hand over the session to our speaker. Over to you, Appurva.
Okay, thank you. Thank you and welcome everyone. Warm welcome to all of you. Good evening, good morning, or good afternoon, depending on your location. So to get started, here is the quick agenda for today. The session will cover the basics of upcoming India DPDP Act, which is Digital Personal Data Protection Act, snapshot of the act, the differences between the India DPDP versus EU GDPR, because GDPR being the gold standard, the FAQ from what we have heard, why we should start working on DPDP when it's still not in effect, and accordingly, what should be the roadmap to minimize the risk of non-compliance when it does come into effect. So we'll be trying to cover this over the next 30-35 minutes in this webinar. In case you have questions, please feel free to type into the Q&A section. Let's get started. Okay, so just before we get into the dive into the DPDP Act, here is the quick snapshot of what Renal talked about, the data governance. So this is the course, the whole training program which has been developed by me, data governance, and talks about the data governance framework, data governance operating model, the policy, roles and responsibility, the chief data officer, the DPO, the CIO, the data governance office. So everything over there. And one of the chapters, which is what we're going to be talking about today, is data governance in compliance, privacy, and security. So how this program support the overall data governance. There are other chapters also. You can see the link. It is under the Code Red EC Council course, Deploy Data Governance and Compliance. So once once you get the heads up into one of the topics which are there in the data governance, I'm sure you will find the overall course training on the data governance helpful towards your day-to-day work. With that, let's move. I'll skip my introduction. It's already been done, so we save a couple of minutes over here. My contact details are also there if in case you would like to reach out to me in future. Okay, so getting on to the India DPDP Act, as I said, it stands for Digital Personal Data Protection Act. So what it means, the new Digital Personal Data Protection Act 2023 is a game changer for organizations. It introduces stringent data protection challenges backed by fines and penalties. The law applies to personal data that were either collected in digital or non-digital form and were digitized thereafter, but does not apply to public information or data processed in household/personal context. Now, what it means, first of all, the act has been, it has gone through all the required parliamentary approvals, even the president assent. So it is an act now. However, it has not come into effect. So that's why you see 2023. It is expected to come into effect sooner than later. We do expect it to over the next 100 days or so that the act should come into effect. Reason being, the delay is at the end that the data protection board is being set up, and accordingly the data privacy policies and rules, etc., are being set up. So that's where it is right now, and we expect it to really come into effect sooner than later. The application of the law is to the digital data. That's the first and foremost thing which needs to be understood, as the name of the act itself is Digital Personal Data Protection, which means if it's a pure hard copy, so you have taken a photocopy of any of your ID, that's not covered under this act. However, if you scan that paper, then it does get covered because then it's a digital form. So this is very important to understand that it's for the digital data. The second thing, it does not apply to public information which is available in public domain or the data processed in the personal context, household context, like you sharing your personal details in a family WhatsApp group. So like this, it is not applicable either in public domain or in the personal context which is over there. The processing of digital personal data takes place within the Indian territory. The processing of digital personal takes place overseas, but offers its goods and services to those in India. Now, this needs to be understood very clearly, whether you are processing it within the Indian territory or outside. As is the case with the GDPR, this is also an extraterritorial law, which means any Indian citizen in any part of the world can be. However, the company is offering goods and services to that citizen, the law will apply. So it's very simple. Even if a foreign company which doesn't have any office in India or any processing is sitting somewhere in Africa, Europe, or Asia, but is offering services or processing data to an Indian citizen, the law will apply. So as is the case on your left, what is in scope? This is generic, but I still wanted to, so that everyone is on the same page. The data types examples are name, email, phone number, address, medical data, passport, ID cards, images, behavior patterns, shopping interests, etc. All that constitutes as what we called as data types. Then comes the data subjects or the data principles. So the terminology is slightly different. What you call data subject in GDPR are known as data principles, and in the India DPDP Act, for end customers, clients, employees, third parties like vendors, distributors, service providers, all of them, anyone having personal data is considered the data principle. The activities are again simple: collecting, processing, and storage of data to be checked along the data flow. So if you are doing any of this, you are under the ambit of this act. With that, we will just move forward. This was a very basic background about the act, and I'll just try to give you a quick snapshot. Will not spend much time. The scope of a bill is limited to personal data. I've talked about it. Is collected online, or personal data which is collected offline and subsequently digitized. That's important. Very, very significant, important point. Why organizations really need to take this very seriously. The financial penalties for data principals can go up to, I'm sorry, the financial penalties for the data fiduciaries, the data controllers in GDPR is known as data fiduciary. In the India Act, the penalties can go up to 250 crores INR. This is significantly higher than any other law in India. So in that sense, no other law has this amount of penalty which has been prescribed already as compared to which is more based on certain case to case. So yes, it can go from 10,000 rupees to 250 CR, which is we're talking about in billions of rupees. But yes, that has been already prescribed in the law. So there has to be grounds of processing. Then there is also a very, very important one, significant data fiduciary. We will cover this point later in the webinar. There is data fiduciary and there's significant data fiduciary, which is one of its kind. Again, comparing it to any other global data privacy laws. Transfer outside India's, that's the cross-border transfer. We will talk about that. The consent, breach notification, the data principal rights. Data principal rights, right to obtain information, correction, erasure or to be forgotten, grievance redressal, and right to nominate. Those are some of the rights which have been granted. Okay, DPIA to be conducted, DPO to be appointed, etc. We will talk about that in subsequent training on this one. So yeah, the important takeaway is the penalty, which is first of its kind in any of the India laws which are there in place. Okay, now we come to the comparison, the India Data Privacy Act versus EU GDPR. What are the differences? This is important to understand because a lot of companies which have already been working on GDPR implementation, even though it is not applicable to them, but as a golden standard, they would need to do a gap assessment again on this part to understand the differences. So the data categorization is different. First thing first, there are special categories of data or sensitive data, as we know in GDPR. If you have special category of data such as racial or ethnic or political views, in the India DPDP, there is no difference in the data. There is no special category. So what it means, the personal data of a name and a phone number has the same criticality as of a medical data or of a biometric data. So there's no differentiation. So the companies have to be, the law applies, and therefore the companies have to follow the same stringent measures as they would do for special categories of data. That's the first and foremost requirement. Grounds of processing, this is the India DPDP is very consent centric and legitimate interest limited. We need to understand this. It's very, very consent based. We'll talk about consent further ahead because consent does play a very important role in the India DPDP. Whereas in the GDPR, there is broader legitimate interest of processing. So legitimate interest, like we've talked about, example would be an employer processing employee personal data, because they have to process the payroll, they have to give them medical insurance, etc., appraisals and everything. So there's a legitimate interest of the employer to do that. Whereas in the India one, it's more consent centric and legitimate interest is very limited only in certain scenarios. The type of actors, the definition is different. I've talked about it. A data controller in GDPR is known as fiduciary. There is another new term which is significant fiduciary. There is processor, which is no direct. And that's another important point. In GDPR, with the revised version, there is also the cost of non-compliance, or the processor can also be fined. Whereas in the India DPDP Act, there is no provision. Single most responsible entity which will be fined in case of non-compliance will be the data fiduciary. So data fiduciary has to be extra careful with their third parties, with the processors, because if even the processor has a fault, it will be the fiduciary who will be held responsible. The children's data, the age is different. It is 18 in India, which is a very, the very regular age for most of the, activities. When you're talking about like a driving license in India, you can do it after 18. So same is being taken over here. Age of consent is 18, and there has to be a verifiable parental consent before 18. Whereas the GDPR says it is 13 to 16, which is fair enough. but the difference is there has to be reasonable effort. So there's a difference between a reasonable effort versus verifiable parental consent. So significant difference when we come to the application of it. It's not going to be just a reasonable versus you need an evidence which can be verified. That's very important. Retention timelines, rule to prescribe specific timelines for data retention. So GDPR has controllers determine retention period subject to justification. So the controllers or the data fiduciary, the organization, based on the various regulatory requirements or legal requirements from various type of documents, can self-determine how long they want to retain the data. To give an example, an employee data by HR, an ex-employee data by an HR can be retained for 3 years, 7 years, whatever they feel like. That's going to be very, very different in the India DPDP Act, because the Data Protection Board going to come up with the rules which I talked about. That's one of the 2 things which is undergoing. The rules will be prescribed where there will be specific timelines for various documents. This is what is expected from these rules. Again, significant difference. You won't have a choice, which is, I think, is much easier to follow, because it does get a little confusing if everyone is doing it as per their own justification. So I think this is more easier as in the India one, but that's going to be the difference. Again, breach notification, the GDPR again has a bit of subjectivity, which says risk-based breach reporting, only high-risk breaches to be reported to the data subjects and to the data privacy board of the country. But how do you determine high-risk breaches? So that's been a point of debate always. In the India one, it is simple. Whether it is 1 or 1 million data breaches which has happened, for every breach, the data fiduciary is supposed to report this to the Data Protection Board and to the data principals / data subjects. Rules to be prescribed. How, and the timings and everything will be prescribed, but everything needs to be reported to the data principals, to the end consumer, to the client, this thing. So this is a very, very major difference. What it means, there will be extra work for the data privacy officers and the team, because everything would need to be reported to the Data Protection Board and to the data principals. Cross-border flows. In GDPR, it is permitted through adequacy decisions, as we know. Once if the country has been deemed adequate, you can do that without any worry, or you can do the SCC, the standard contractual clauses, or if you are BCRs, signatory to BCRs, or as an organization. So within the the MNCs can they are BCR compliant, they can transfer to the other entity very easily. But it's going to be different in the India market case. There's going to be only it's permitted to all except to the blacklisted countries. Now this is where the catch is. The blacklisted countries are yet to be announced. It is expected on the certain previous provisions, some of it like the countries sharing land borders, etc., which is in some of the cases of imports, electronic imports and everything. So the expectation from the industry is going to be on the similar line, but it's not yet out. Again, this is as part of the rules that it's going to come out, which are those blacklisted countries. So you can do a data transfer except for the blacklisted countries. Now it is easy, but it's also stringent, because some of these blacklisted countries may be the top countries where there are a lot of servers, especially in case of MNC companies. If their home or the group companies headquartered in one of these blacklisted countries, it will become problematic. They would need to think through about it, the whole data flow, where their IT infrastructure is, their network, and everything needs to be thought through in this case. So easier but stringent. Consent manager. Now this is a very, very new requirement. So let me read that out first. New institutional mechanism for consent management must be registered with the DP board. Now this is one of the things which really needs clarification, and once this data privacy board is set up, once the data privacy rules are out, that is when we expect to hear more on this. So the consent manager, it's a unique requirement. It has not been defined anywhere in any other data privacy law across the globe. It's a very, very new requirement. There is confusion. What is this consent manager supposed to do? There will be roles and responsibility. We understand some things like, we need to have a very explicit consent, not the deemed consent. There has to be clear opt-in and opt-out procedure. But then the question which is there, who's going to be the consent manager? Will it going to be a human being? Will it going to be an individual? Will it going to be a separate position? Or can the DPO also be a consent manager? Can can AI or a robotic tool can be used as a consent manager? So there are these questions which are there, and there is a lot of clarity. So out of all the provisions which are there, this requires the most clarification as of now, till the time we don't have the data privacy board and the rules coming out. So I hope this is understood. Okay, so sorry, I missed one of the things which I wanted to explain. There is this data fiduciary and the significant data fiduciary, which I've talked about. So significant data fiduciary is something which will be considered based on the volume of data and the type of data. Again, there is a bit of clarification which is over required. For the significant data fiduciary, there will be additional responsibilities which are required. So for example, in GDPR, everyone needs to do the DPIA. That's what is recommended, right? But in the India DPDP Act, a significant data fiduciary is mandatorily needs to do the DPIA. So that's one of the major things. The significant data fiduciary mandatorily needs to appoint a DPO. Whereas the data fiduciary or a simple data fiduciary does not need to do that. So there are few differences, couple of more, which are over there, but that's what is being described as significant fiduciary versus a fiduciary. The clarity on what is going to be the significant fiduciary, as I said, it's definitely going to be on the volume, it's definitely going to be on the type of data you are handling. If there is any risk to the national security. So to give an example, a telecom company or an internet company or an IT technology company which is having some sort of, for example, if some of you would know about Aadhaar card. So for example, if there is any private companies, or a government organization also, where there can be potential risk to the national security, those what will be determined as significant fiduciary. So that's another important difference which is over there. Again, it's new concept which has not been there in any other act. Okay, so I think you got the brief flavor of what is the India Data Privacy Act, how it has come into effect. What I'm gonna talk about is something which the questions which I get asked very often when I'm talking to the clients. The question which comes is, the law is yet not in effect. Why do we need to worry about it now? We will see when it comes. We'll cross the bridge once we reach there. But there is this question which is over there. So what I've tried to explain over here, that some of these FAQs, I've just put it for you. I'm sure some of you would also have it. Now, in today's digital environment, data privacy and security is not a choice, but a compliance-driven necessity focused on safeguarding user data. Now, the key point over here is the penalty, the cost of non-compliance is up to 250 crores INR, which is a very, very, very significant cost. Even for big corporates with deep pockets, just gonna pinch. So we're talking about billions of rupees, easily about 25 billion INR what we're talking about over here. The data, and also remember, as I talked about, data fiduciary will also be responsible for non-compliance by its third parties or the processors. So even if they mess it up, it's going to be the data fiduciary who's going to be responsible. So first of all, we need to understand the cost of non-compliance. When is the DPDP Act expected to come into effect? As I talked about, it is expected from our industry sources that it is going to be next 100 days. MeitY is in process of setting up a regulatory board and finalizing DP rules. However, this is not confirmed. There is no official confirmation based on generic feedback which is over there. Why we should start working on DPDP Act when it is still not in effect? That's the whole question. It is widely expected the Act will come into effect immediately or on short notice. That's an important thing. Now, this I'm going to link this to why the cost of non-compliance or the penalty which is over there. So it is expected that it will come effect immediately and on short notice. We do not expect that there's going to be a major time frame to be given that, okay, the companies will have 6 months, 1 year to ensure compliance before it comes into effect. That's not going to be the case. That's again a reasonable feedback or belief which in the industry has. In that eventuality, there are some requirements with external implications, which are data principal facing primarily, like privacy notice, like data breach, etc., will be more critical and immediate as compared to internal documentation like impact assessments, agreement, etc., which can be worked upon in due course. Hence, for the external requirement, it is recommended that the work should start now. So what we're trying to say basically that yes, the law is not in effect, and I will talk about the roadmap for all of you if you're going to go back to your organization, that how what should the approach, because remember, to the data privacy is such a topic that it is a mix of policy, it is the IT changes or the IT development part of it, the security part of it, and also very important, the training and awareness of employees, because ultimately these are the people, we are the people who are going to do it, and all this takes time. So assume that it has to come into effect, let's say by October. Even if we start now on implementing at least the basic external threats or the risk which we have, the high risk item, the external implication like privacy notice, like data breach, it's gonna take time. It's not gonna be a 15 days or a 1 month job. All this is gonna take time, writing up policies, making system changes. You may need to engage with the vendors, getting the RFPs out, getting shortlisting the technology vendor. All this takes a lot of time. We're not about months, we're talking about a year or even more than that. So that's why we are, even if we have to start doing the high risk items, it's going to take time and it should start now. Also, this is very important for all of us, all of you to understand. One of the unique requirements in India is the language, the regional languages which are over there. There is a clear requirement that the privacy notice has to be in 22 regional languages. I mean, depending on the nature of the business, where are you serving, so there, for example, on the phone, when you buy a new phone these days, you can select regional languages. There are various 22 Indian regional languages. So if you're somewhere from Bengal, you can select Bengali as a language on the phone. Therefore, what it means, your privacy notice cannot be in English. It also has to be in Bengali, the language, the data, the client can understand, the data principal can understand. There is a lot of work on this, the local language, the regional language part of it. So that's why I'm highlighting it again, that the critical things should start now, and some of the things can go along in a different phased manner as and when the act comes into effect. What should be the roadmap to minimize the risk if non-compliance when DPDP Act? So perform gap assessments, identify tasks with external implications, as I talked about, identify system changes to enhance data security, identify internal tasks to be completed in due course. So I will talk about it in the next slide, which is also going to be our last slide for this session. But this is what it is, that there is a roadmap, which is what I recommend to all my clients. And you can reach out to me, if beyond the session also, on LinkedIn or on my email, as the case may be, and I'll be happy to share this roadmap. So this is the roadmap which I am suggesting to most of our clients, that what we should do now. As you can see, there are milestones on the left. In the middle, you see the phase one, which is the external impact, which is more immediate, which I said will be applicable from day one. To take an example, if you have a data breach in your organization on the day 10 when the law has come into effect, would there be any flexibility, or will there be any leeway from the regulators or the data privacy board that, oh, just because the act has come into effect 10 days back, we won't fine you? No, that's not going to happen. If you're going to have a data breach when the law has come into effect, even if it's day 2, you're going to attract penalties. What it means that the breach you would need to complete your obligations of informing all the concerned, the data principals, the data privacy board, and everything. So that's what I mean, which has external complications. And on the right, you are seeing the internal changes, which are, some part of it awaits the rules from the data protection board. Those can be picked up in the due course in a phased manner. This is very, very suggested roadmap. It is not casted in stone. So again, organization to organization, business to business, data to data types, it will vary. And again, those are the discussions which we need to have. But there's a very, very, you can say in a descriptive way, I've tried to put it over here, more symbolic, this thing. So first thing first, companies which already have done the work on GDPR or any other law, there should be a gap assessment where you should know that, okay, these are the differences and this is what we need to do. This is what we don't need to redo or rework, but these are clear changes. Does require system changes, does require policy changes, training changes, operational changes, all that would be there. Defining purpose and privacy policy, it's very, very important. Most of the Indian organizations does not even have privacy policy in place. So it's very, very important that should start immediately. Breach management, the example which I gave, it doesn't matter when it happens. If it happens, it's going to have a same sort of implication, liabilities, and the penalties in the case. Data principal request management. So if you get a request from data principal, tell me what all data you hold for me. So do you think at this moment, in your organization, you have 20 systems internally, you have third parties, vendors, suppliers, you have dealers, retail stores, depending on the type of business you have. They are not your employees, they're your third party, they're your dealers, but you are sharing data with them, right? So which means they have the data. Let's take an example of a car manufacturer. So any company, car manufacturing company, has the data of the individual who has purchased that car, what is their address and everything. But so does the dealer has that data. Now, are you aware? And so that in the entire supply chain, there will be a lot of personal data which will be available, from insurance company to warranties and everything. Your roadside assistance, a lot of third parties are involved. Do you think as an organization that, let's say today, if you get a request from a data principal, tell me which all data you hold for me and which all systems, are you in position to know which all system do you hold the data? Are you reasonably confident? Do you have the data discovery capabilities to be able to identify where all the data is stored, which all third parties, including my in-house systems? I don't think anybody is. Even today with the GDPR, a lot of international organizations are struggling with the data discovery. That's a fact. We do have reasonable knowledge, but that's taken a lot of years. We're talking about more than 5-6 years of GDPR, 6 years of GDPR coming into effect, and companies are still on the journey. So it's very important to understand, this part. Then there are other things like cross-border data flows, data processing agreements, data security, ID controls, consent management. This should start somewhere in between. Don't wait again for the rules to come up, because we know certain part of it what's going to be there. That can start because a lot of these works are very voluminous and they take a lot of time. Data security, if you have to start changing your systems, you have to start upgrading your system. So for example, for data security, you want to do data encryption, or you want to do multi-factor authentication. All this takes time. From the IT perspective, you're going to go out, find a vendor, service provider, you're going to do your comparison, you're going to do your budgeting, the vendor going to come on board, the implementation will happen, the user access testing will happen, then you go live, then there are all issues, interface issues, data transfers and everything. It's a whole lot of work. We're not talking about weeks and months, we're talking about year and a half, these system changes. Same with data processing agreements, a lot of document writing, reaching out to all your third-party supplier. That can be really, really voluminous task and manual task. Consent management, as I said, 22 regional languages, very, very important to understand the depth of this requirement. How much it is asking. You got to be able to do it in Odia, you got to be able to do it in Bengali, in Tamil, in Kannada, in Telugu, in Punjabi, loads of 22 languages which we are talking about, in Marathi and everything. So we got to be careful on these things. So some of this work should start sooner than later. And then there's the last bit, which is on the retention timelines and the purging and the significant fiduciary obligations, which I talked about. That we should really wait for the rules, because that's what the rules will determine. And I think that's what we can put as purely as a phase 2 activities. We can really wait. Fact is that we have so many other things to do now that some of it will take time once we reach over there. So this is a suggested roadmap. As I said, this is not something which will be like copy pasted for everyone. Again, depending on the type of organization, some of these steps may be there, may not be there. For example, gap assessment, if you're purely an Indian company which has never done anything on data privacy, the gap assessment is not required. We know we need to do everything. We just need to go ahead and start doing it, all these things which are listed over here. So yeah, so that's it from my side for the session today, and I think I'm bang on time also. So now happy to take questions from my side. We can proceed. So I hope you found the session useful. I think if I will be a little quick, please excuse me for that. I can cover up that with the Q&A because we do have good amount of time for the Q&A for everyone to ask question. As I said, I am working as currently as GM and practice it for data privacy and security with Vincula. Here is my email ID, appurva@vincula.in, and my LinkedIn profile, appurva.bhatia. So that's my contact information, and happy to connect with any of you as soon as possible. Over to you, Renu. Happy to take Q&A from this point onwards.
Okay, thank you very much, Appurva, for delivering such an insightful and informative session. We found the webinar very engaging and hope it was valuable for you as well.
Thank
Before
you.
we Yes. Before we begin with the Q&A part, I would like to inform all the attendees that today's session is in sync with EC Council Learning. So if you're interested in learning more about data governance and compliance, the popular course on EC Council Learning, Deploy Data Governance and Compliance by Mr. Appurva Bhatia is ideal for you. Here's a quick preview of what's covered in the course. Exclusively for the attendees of this webinar, we are offering a special 20% discount on this course, but only for today. The link to purchase the course and the coupon code are mentioned in the chat. Also, if you would like to purchase the entire EC Council Learning Library of over 600 plus online courses, there's a 30% off exclusively available for today. There's no need for a coupon. It's already applied. Please check the link in the chat. So shall we start with the Q&A, Appurva?
Yeah, we can go ahead.
So our first question is, who will define blacklist countries?
Yeah, so that's going to be defined by the Data Privacy Board, the Data Protection Board, which is being set up. They will be coming up with the list of that country.
Okay, thank you for answering that. Our next question is, how does this apply or affect US universities that Indian students are attending?
Oh, absolutely. So like, for example, I mean, like CCPA, which is over there, as I explained, all these laws are extraterritorial, which means it's not just limited to the geography or that country. So an Indian student being approached by a US university to enroll, to take admission and everything, and then accordingly processing their personal data for the purpose of enrollment, for the process of visa processing, which means they are collecting the personal data of an Indian citizen. They are processing that data. Therefore, the India DPDP Act will apply on them.
Thank you for answering that.
Question.
Okay. So thank you for answering that, Appur. Our next question is, okay, how can a country that is so corrupt expect to enact and enforce this type of act? Same question applies when enforcement is done internationally.
Well, I mean, to be honest, I really didn't get the question, but I think whatever I've got, I mean, how can do it doesn't matter. I mean, if there are two wrongs, doesn't make one right. Uh, if there is corruption on other level, the attempt through this act is to curtail that corruption. So every country is free to enact the law. It is being done with the good intention. Now, if there are other things which are happening, yes, there are. I mean, the fact that today, a data theft by the international cyber hackers, and or certain countries which is going to be there in the blacklisted countries or not so friendly countries. Today there is no law. If they do it, there is nothing which is over there. If the Indian citizen data is compromised, there is no law to to penalize those culprits. With this law, there is an attempt to stop that, and obviously put a cost of doing this. And companies which either belong to those countries are involved in doing that. So yes, I mean, to be honest, why it has been enacted is a question is very simple. The world is moving to digital data. Data is the new oil. Data is the new gold. So everyone wants to protect data, and so is what India is trying to do. And I think that's where I would kind of leave it to this question.
Thank you, Apur. Our next question is, in recent data breach that happened in WazirX, the crypto platform, as the cryptocurrencies are not legalized now in India fully, will these types of data leaks incident will come under DPDP Act?
Uh, Ideally, yes, it will be because it belongs because the data which is contained is of an Indian citizen, legal Indian citizen. So the personal data of a legal Indian citizen, therefore, it will come into the impact. The cryptocurrencies are not legalized from RBI perspective. Yes, I agree because that's something which is being debated. But the way Data Privacy Act gonna come, it's gonna be overarching. There are a lot of other acts which does have bits and pieces of data security provisions, like the Information Technology Act or IRD, the Insurance Regulatory Authority, which is over there. Similarly, RBI does have a requirement of data security, but they are bits and pieces. So this Data Privacy Act will be overarching, and because it will have the data of legal Indian citizens, it will be applicable.
Thank you for answering. Our next question is, how does the DPDP Act can affect the data during international data transfer?
Okay, so from an international data transfer, the main point is about the blacklisted countries. So what it means, so okay, so in the GDPR, there are provisions. If you're not an adequate country, or if your country which does not have a data privacy law, there are options being given via a contract. I mean, whether you call it as a data privacy agreement, whether you call it as a standard contractual clauses agreement, everything, there are provisions which have been given that, okay, this is how you can do the data transfer. But in the India Data Privacy Act, it's very simple. You can do it, you don't need anything, or you can't do it because it's a blacklisted country. So it's very simple. That's the first and foremost thing in the cross-border data transfer. So if it's a blacklisted country, you will not have a way out. Again, it will depend what type of activity you are doing. So if there is a systemic data transfer, that won't be allowed. If you have bought something, and as part of servicing, you are that company, call center, customer care is based on over there, you are importing something from that country, yes, that's transaction to transaction, which will vary. Again, the rules are not out, so I'm trying to give you a generic picture of it, but a systematic data transfer won't be allowed. So let's say if your company headquarters is in one of those blacklisted countries, and therefore all your data servers, cloud servers are also in that country, and every day there's a data backup. So that's what we mean by systemic data transfer, or everything gets transferred to that country, can be accessed in that blacklisted country. That won't be allowed. Transactional things which require certain servicing, as I said, customer care, etc., that most likely will be allowed. Again, we'll have to wait for the data privacy rules to come. But yeah, and then once a country has our Indian citizen data, they are under the ambit of Data Privacy Act. So which means they will have to fulfill all the obligations from data breach perspective, from data principal rights perspective, from consent manager perspective. All and every provision of the Data Privacy Act will have to be followed by that company, irrespective where they are located.
Thank you, Appurva. We are receiving a lot of questions. So our next question is, will the DPDP take priority over GDPR or work in conjunction with it?
Okay, so ground rule, the law of land takes precedence up against any other law. So it's very simple. So a GDPR in Europe will take precedence over any other law. In India, a DPDP Act will take precedence over any other DP law. Even if, let's say an organization, let's say a European organization having a big Indian entity. So they've been following GDPR. Now GDPR says you have to go left, but the India DPDP says you have to go right. I mean, there is no such provision. I'm just kind of trying to give an extreme example. But for an Indian entity, it is very clear. Whatever the local law of the land will say, you have to do that, even if it's an extreme thing. It is not there, but let's take let's take some of the examples which we have been talking about, like data retention. So in GDPR, it is as the choice of the organization, you can define the data retention period based on your requirements. But in India, it will come as part of the data privacy rules. So if you have to retain something for 5 years, you have to retain. After that, if you have to delete, you have to delete. There's no option. There's no choice. Whether you just don't have to delete in the Indian servers, you will have to delete in even the foreign servers, because that's the data of Indian citizens. So that's where the local law will take precedence. Any other example, like the legitimate process, the purpose of processing, as we call it, when India it is consent based. So whatever other additional requirements or different requirements have to be followed in whichever country you are registered. That's a simple local law of land take precedence.
Thank you for answering that. Our next question is, on what basis the penalty will be decided? Like GDPR used to have penalty of overall 4% of annual global revenue.
Again, in GDPR also it is up to 4%. So in the India DPDP it is up to 250 CR. So it's all up to always. Now that is the all, if you see whether it is GDPR or whether it is Singapore PDP, any law which is over there, the authority, the regulators have this subjectivity which is in their hands. They would look at the severity. They would, one of the things which a regulator always look at is the intent of the organization. Was there at first place a basic data privacy framework, data governance framework in place? So going back again, the larger picture is data governance. Data privacy is one of the elements of data governance. So as an organization, if a regulator sees that, okay, you are trying to do things which are over there, there are systems in place, there are structures in place, you are training and awareness, your intentions are right, but still, because of human error, the data breach happened, for example. In that case, where I have seen from my experience in dealing with such cases, the regulators always take slightly lenient view, because they recognize that you attempted to do right, you are in process of doing some things, there are changes which are happening, human error or the design error, as the case may be. So they always take a slightly lenient view, but as I said, that good the data governance what is the intent behind it, are there being right policies or not. So they look at the overall picture before they come up to the penalty figure. Yeah.
Thank you for answering that. Our next question is, does DPDP Act applies to stockbroking business?
Sorry, does it apply to stock
Broking business.
broking business? No,
Yes,
no,
stockbroking.
nothing. There nothing is to stop. It is basically that you can do your activities, but you have to do it in a prescribed manner. You have to do as per the rules and regulations which are being over there. So for example, the example which I took as an if you're an online e-retailer which is over there, somebody logged onto your site to purchase a particular item, and they you collected your name, address, phone number to deliver that item, and that's what the purpose was. That's what they consented for. However, you cannot then sell this data to third party. You cannot give it to the other organizations internally, to your other departments, and start reaching out for new products, for marketing, etc. If you want to use the data for marketing, you have to have that consent. You have to be very explicit about it. So the purpose has to, what you collected for should be maintained. That's what it means. You cannot start using it for any other purpose, for trend analysis, for historical. If then you will have to do data anonymization, etc., which are over there. So it's not to stop any broking business, nothing as such which is over there, but it has to be done in the prescribed rules and manners as defined in the law. That's what it means.
Thank you, Appurva. I'll take the last question for the day. Does DPDP Act can generate new job opportunities?
Oh, I mean, trust me, this is going to be the next. This is the next hot cake. Lot of it, and especially in India, it's going to be huge. And I can tell you many reasons for that. So first thing first, in India, this is a foreign concept. So the companies, some people people who have been working with the multinationals are aware of data privacy as a concept. First of all, they're just aware. People just know there's something called GDPR, but they don't know the details of it, the technicalities of it. What is it? What does the transparency means, for example? What are data subject rights? People don't understand that. The organizations don't understand. The biggest thing is the Indian consumer doesn't understand. The Indian consumer doesn't understand today that they have something called rights, that they can ask an organization, please delete all my data. I took a policy, or I did some transaction with you 10 years back, delete my data, stop calling me, stop using my data, or etc. This is the biggest change. And with the today's digital day and age, 99% of the companies which are existing have personal data. Anything which gets linked to an internet, it automatically has personal data. Even if you're not logging on anywhere, you're not, okay, even if you just log on to a website, you don't share your email address, you don't give your name, you don't give your phone number. Purely by virtue of logging in on the internet, your metadata is automatically transferred to that website. Metadata means your IP address. Metadata means your geolocations. That's your personal data. Through that data, they know where you are. They can know through various cookies, crawlers, and everything. They know from this site which site you're going. They can make out, that's what the AI is all about. So powerful. They can, they can analyze that on first week of every month, you generally do your shopping, you buy new clothes. They know by that generally your shopping range is between 5K to 10K every month. This is what your taste is. This is what you like to spend upon. This is, when you go for movie nights, this is when you go for parties and everything. So without even giving your name, etc., they can still track you, because the metadata tells this is the phone, this is the geolocation, this is the IP address where they log in. They're logging in from Delhi, Bombay, London, wherever they are. This is the person who's going from here to here physically, because your locations are on your phone. So anything which gets connected to internet, anything which gets connected to Bluetooth, anything which is on computer is today automatically under the ambit of this law. So I cannot kind of even explain beyond this. I've given you three reasons. In India, for organization, it's a foreign concept. It hasn't existed. People haven't worked on it. There's a whole lot of work needs to be done. The biggest the number is of the consumer. You're talking about more than 1.4 billion of people, out of which there is 60-70% people using mobile phones, which means close to 1 billion people personal data is in under scope over here, this law. This is the population, this is the humongous size of data principle or a data subject as we talk about over here. And the third bit which I talk about, there is hardly any industry, there's hardly any domain, from medical, from pharmaceuticals, from mobile phones, from electronic media, anything and everything from basic fridge, appliances, home appliances, everything today is smart. There's a smart TV. Everything is connected to online. Everything is on internet. Everything is under scope. So I cannot explain beyond this that what a huge scope in India it is, with pure sheer number of people, the sheer number of population, the foreign concept it is, for companies, and the way the world is moving toward the digitization of the data. So it's got an unlimited, you're talking about infinite scope, basically.
Thank you, Apur, for answering all those questions and for the great presentation and the knowledge you have shared with our global audience. It was pleasure to have you with us, and we are looking for more and more sessions with you. So before we conclude the webinar, would you like to give a small message to our audience?
No, guys, I think the last question was very apt. That what is the scope of data privacy in India? It's humongous, as I talked about. But data privacy is one part of it. There is data security, there is data governance. I mean, forget everything else. The world is changing with this AI, the artificial intelligence. How it's gonna move? Everything is data based. There are data lakes where you have millions and billions of data sets which are over there. Everything needs to be secured. Data needs to be anonymized. Some of it will come under the ambit of data privacy laws. That's why every country is coming up with a data privacy law. So what we are basically talking about, how organization can manage data, how well they can secure it for the sake of their clients, for the security of the data, for the safety of their identity, and how well they can utilize that data, because that's a business opportunity, that's billions and billions of rupees and dollars. So it's so the data governance is the larger umbrella. And I think the course which I designed for EC Council talks about that only. What are the roles of chief data officer, what are the roles of data privacy officer, what are the roles of data governance office, what are the policies, what you need, what are the training and awareness an employee should have, your third party should have. So please try and go through that training. It will be very, very helpful, because in today's world, nothing is more significant or bigger than data. We know from the past instances how the data has been used to influence elections, how people have changed, how the social media works. So it's amazing. And the attempt in the data governance training course attempts to do that. So please, go through it. It will give you a good guideline, and obviously it will be short course. But if you wish to pursue it further into the world of data governance, best of luck. That's the future.
Thank you so much, Apur, for the message to our audience.